So hi everyone again, and I welcome on board all the participants and panelists joining up for this session. So now we are having our last panel discussion for this conference, and the topic is informing and influencing trademark issues arising in global advertising. So we have our speaker joining from Kritika Seth, and she's joining from Victoriam Legalis. We have Zun Yang joining from Llinks Law Offices. We have Varun Sharma, Associate Partner, joining from LexOrbis. We have Chinasa Uwanna, Senior Associate from Banwo and Ighodalo. And we have Surabhi Iyer joining from Sagar, Chandra and Associates, Managing Associate. I would like to say that Omesh is unable to join us for this conference due to some emergency at his place. So we are having Varun Sharma joining up on replacement of him. Thank you. So I would request Lily, that is Lily's our moderator. She's a General Counsel, Amcor Flexibles Asia Pacific, to drive the conversation forward. Thank you. Over to you, Lily.
Absolutely. Well, thank you very much for that very kind introduction, and thank you everyone for giving us the opportunity to speak to you as the last panel session for today's conference. I understand it's been a very good day so far, so hopefully we're able to continue that with this last meeting. It obviously gives me great pleasure to address you as part of this virtual IP conference, which I understand is the last of the series for the year. My name is Chen. I'm the General Counsel for the Amcor Flexibles Asia Pacific Business Group. Amcor Flexibles Asia Pacific is one of 6 operational business groups comprising the global packaging company Amcor. I am based in Singapore, and as part of my footprint, oversee 8,500 co-workers across 40 plants and offices in 11 different countries. So the topic, as you know, for this panel session today is informing and influencing trademark issues arising in global advertising. Now, as many of you would be aware, a trademark is a legal means to protect the intellectual property associated with an identifier of a business. A trademark can be in the form of a symbol, a logo, a design, a word, a slogan, colour, or even a combination of several elements. And in some jurisdictions, sound, smell, or taste can even be protected as a trademark. And for example, even shapes can be protected as trademarks. Lego, for instance, is one example of an actual item which is trademarked in itself. Trademark registrations add value and certainty in a company's rights for investors and buyers, and legal protection of trademarks is of utmost importance, especially considering the efforts which often the marketing department has spent towards defining and documenting the company's unique selling proposition and brand strategy. Indeed, trademark applications and registrations can allow a company to protect its mark from third parties before it even begins to use that mark in a foreign jurisdiction. But even if we know all of this, what often happens is that a company's trademark becomes confused with its brand, including its brand name or trade name. A trademark or trade name, as you would likely be aware, is a name under which a company pursues its business and is distinguishable from the company's registered or legal name. A company's brand, on the other hand, exists only intangibly in the minds of the public. With all of this in mind, what are the trademark issues which arise in advertising? And how do we work effectively with our sales, marketing, and advertising teams to protect a company's by way of trademarks? To help answer these questions and more, it gives me great pleasure to introduce you to my esteemed co-panelists. We have tonight Mr. Ravi Iyer, a Managing Associate of the Prosecution and Transactional Department at New Delhi firm Sagar, Chandra and Associates. We have Mr. Shun Yang, Partner in the Shanghai office of Llinks Law Offices in China. Mr. Varun Sharma, Partner in the New Delhi offices of LexOrbis. And Ms. Kritika Seth, Founding Partner of Mumbai-based Victoriam Legalis Associates and Solicitors. And last but not least, we have Chinaya Uwanna, Senior Associate in the Intellectual Property Law, Technology, Media and Entertainment Practice Group of Nigerian law firm Banwo and Ighodalo. Sorry, I can't say that name properly. Unfortunately, our time together is only limited, so we're now going to get underway. Now, the first question I'd like to direct is actually to Kritika. So I'd like to start with you. So Kritika, your primary areas of expertise are IP, media and entertainment law. Having advised, structured and negotiated deals for both domestic and international production houses, What do you consider to be the basic trademark issues and challenges which arise in the context of global advertising?
Thanks, Lily, and thank you, everyone. It's really lovely to be a part of this panel. I believe there are multiple aspects that can be looked at when we talk about trademark-related issues when it comes to advertising. Honestly, to begin with, I would say with the current scenarios where we have the digital market, which is like picked up so much pace, there has been a whole lot of conflict that has started to arise because there have been multiple marks that have been used all across the world. However, now they are all coming into the limelight, and infringement seems to be like something that's picked up on quite easily. Also, because now we are using the digital space for marketing and promoting various trademarks, it and their brand values are also like expanding, extensively. I believe there is always that scope where that conflict does arrive. I also feel that there has been like various conflicts pertaining to the kind of the kind of people that we are talking about, the kind of cultural differences that are there that could also lead to somewhat differences and some kind of disputes when it comes to the trademarks that are being used by various companies. In my personal experience, I've had like multiple cases wherein I have personally dealt with a very small scale, a small scale vendor who has been using a particular name and a particular brand, and without even being aware of its existence, like globally. And at the same time, the moment the name comes out, because everybody starts promoting themselves digitally now. So yes, at that point of time, there have been litigations, and it has costed him a whole lot of money because, of course, we all understand when it comes to trademark, it's all about the usage, and how much goodwill the mark already has, the existing mark. So I personally believe that there is a lot of conflict that definitely is there in the market, continuing with the digital space, and also having that very limited knowledge as to the expansion of advertising. I believe when it comes to advertising, a lot of people are not really aware as to how these brands need to be created in order to ensure that such disputes do not exist in the future. So I mean, the whole idea of ensuring that there is a trademark search which is done prior to getting them to be used as trademarks, I believe is something that a lot of people tend to overlook, in the process of having those registrations. So I believe at the later stage, then the disputes come out quite naturally. So yeah, there are definitely like a whole lot of issues that can practically be looked upon, and I'm not going to go in depth about each one of them, but I guess briefly that's what I would say is the main concept that's being dealt with.
Yeah, that's fantastic, and some really nice in relation to, I guess, key issues that people should be thinking about in terms of trademarks, especially when you're approaching this from a global advertising context. So thanks very much for that insight, Kritika. Of course, as everyone knows now, long gone are the days when global advertising was confined to print, television or radio media. The challenge now for brand owners is really how to inform and influence the relevant market whilst protecting one's intellectual property in the new age of digital media. So this question is actually directed to Chinasa. I know that you have worked on numerous local as well as cross-border and multi-jurisdictional transactions which involve brand registration, transfer, commercialization, protection and enforcement, particularly in Nigeria and other African jurisdictions. No doubt some, if not all of your clients have adopted some form of online presence. What are some of the issues to consider with online advertising? And how do you help your clients to weigh up the risks associated with being online versus the desire to immediately influence and inform through advertising?
Has now all the way to online advertising. We had noticed a gradual shift over time to online advertising, and given the fact that we're in a global village right now, which has even become worse now or more common now with the pandemic and the lockdowns that were put in various jurisdictions and all of that. What I would say is that a lot of issues have risen, in my experience. Issues of fair use of trademarks, particularly things that have to do with like maybe keyword advertising or ads on Google and other search engines and things like that, right? For me, what I typically advise my clients to do is to make sure that they have very strong brands. First of all, ensure that they have their registrations done, not just in the local jurisdiction where they participate actively, but in other jurisdictions in the world where they might have some sort of interest. Ensure that there are clear ways of the brands are and what they stand for. Obviously, that would include registrations and things like that. But beyond that, they should be very active in ensuring that it's kind of a balancing act, because on the one hand, you want to be seen, you want to get your brand across to the relevant market and relevant public. And then on the other hand, you don't want it to be something that people would bastardize, so to speak, or start using without any sort of. What I've seen, not just in Nigeria, but even in other jurisdictions, is that the courts typically do not try to restrict the use of brands or trademarks as AdWords or as keywords in searching. A lot of the decided cases have shown that, particularly for a search engine like Google, for instance, there's this hesitation to restrict the use of such brand names or and all that in searching, because there's been a lot of litigation in this regard. However, as a brand owner, I think it's, again, like I said, it's a balancing act. You have to always be aware of what's going on. Check to see whether people have reserved your trademark or your brand name as a keyword, and write petitions or whatever you need to do to ensure that it's restricted, particularly because sometimes online counterfeiters could capitalize on that and try to market their products using their brands. We put some sort of links that would send people to their own counterfeit websites and things like that. Another thing is consideration of what would amount to fair use of a trademark, for instance, in advertising online. Whilst there are some local laws and regulations that have clearly spelled out what would be fair use. It's not very clear cut in every jurisdiction as well. So as a brand owner, again, you have to sort of police your mark and be on top of it to ensure that whatever use that is made of your brand, irrespective of how the courts would lean. Like I said, courts typically lean on not restricting the use of these key brands and trademarks as keywords. Another thing I was going to talk about real quickly is basically, when people have promotional advertisements online as well. You need to be able to distinguish between what is a promotional advertisement and what is actually an infringement of your trademark online. So, for instance, if you are a distributor, you're an auto distributor, and you need to show that you have Toyota brands for sale. You need to be able to draw the distinction between what is just a promotion to show that you have this sort of product on sale online, and what would actually amount to, sort of claiming some sort of connection or undue relationship with the actual brand owner, right? And then finally, what I was going to talk about is local laws. So every jurisdiction has its own peculiar laws that deal with advertising, jurisdiction by jurisdiction. If you're going to be advertising online, yes, it's to the global world, because whatever is put up online is it's ubiquitous media, really, because it can be seen anywhere from every part of the country as long as you're able to access the World Wide Web. You need to be sure that your advertisement generally conforms to at least the minimum standards for advertisements globally. There are certain things that are not allowed online, maybe due to public policy or, basically clearly outlawed in certain jurisdictions. If you want to be able to reach the right people without any checks or restrictions or, preclusion, you need to be sure that you are not going afoul of general advertising law. These are just some of the issues that, I typically face, when I'm dealing with this kind of thing, like use of keywords, online infringement, promotional marketing, and making sure that you're not running afoul of the local advertising laws. Thank you.
That's fantastic. What a wonderful insight in relation to the issues to consider when you're dealing with online advertising. So thank you very much for your practical insights into that, Chinasa. So we're going to change gears slightly, and I'm going to ask a question to Surabhi. You have a specific interest in copyright and entertainment law and have advised clients ranging from MNCs to startups in relation to brand development, prosecution and protection of trademarks both in India and internationally. You'd no doubt be cognizant that irrespective of the form of media used, advertisers will be faced with some degree of false advertising. Such advertising can have a direct impact on a company's brand and trademarks by way of dilution, taint and reputational influence, whether for better or for worse. What exactly amounts to false advertising? And what are the key points which brand owners need to consider when setting about the task of informing and influencing to attract custom to their company and brand? Over to you, Surabhi.
Thank you so much, Lily. Thank you for that question. To start with, I think when we talk about false advertisement, it's defined fairly simply, right? Any advertisement which has a misleading claim would amount to a false advertisement. So therefore, if you think about it logically, there's not much room for ambiguity when it comes to false advertisement. Don't make misleading claims and then your advertisement would not be a false advertisement. But it's not that simple. The reason being that the definitions lie in the ambiguities lie in the gray area of what is truthful information and then what advertisers adapt in terms of creativity, right? So therefore, that is the gray area in which false advertisement lies. So an advertiser might very bona fidely make a statement in their ad. However, when it goes to a consumer, the consumer might be misled irrespective of the bona fide intention of the advertiser. So therefore, the key here, the key to ascertain whether an advertisement becomes misleading or not is the kind of influence that it would have on the consumer. So for instance, if your advertisement is so exaggerated that it can definitely be construed to be an exaggeration and absolutely will have no relation to the reality of it, then mostly courts will hold that your advertisement is not a false or misleading advertisement. However, even if there is a slight chance that the consumer might believe the representations that you are making, even though you believe that those are just exaggerations, the courts are going to just hold that the advertisements are misleading. So because of this ambiguity of definitions, what the consumers need to, the brand owners need to keep in mind are certain broad points as to what should the advertisement content comprise of. Right? So first such point is, if you are making any claims, you should always be able to substantiate it. So for example, we've seen so many advertisements like for toothpaste, which say that 9 out of 10 dentists would recommend this. But if it goes to an advertising body and the advertiser does not have a claim to back this up, it can actually go into the sphere of a misleading advertisement. So that's a key thing to keep in mind. The second thing is the message that you seek to convey through your ads should be very clear. It's very easy to make a statement, but then by withholding clarification of that statement, you are misleading consumers. So for instance, if I'm an advertiser and I say that only my product is going to give you the result, the implication of that is that the other products are not going to give you the result. Now, though you have not directly stated that, but that's an omission. And that omission, that absence of material itself can also be held to be a misleading advertisement. Right? Now, another thing is an ad should not exploit the lack of knowledge of a consumer. So your ad cannot contain a content which a person who knows about the product, who's aware of the either technical specifications or technical results of the products would be aware of. But an average consumer who is not well aware of the product or service that you're delivering is not aware of. So if your ad, even though it could be an exaggeration, but that exaggeration would only be understood by a person who has a background knowledge, that would still be a misleading claim. So that is another key aspect to remember when you are talking about a misleading advertisement or a false advertisement. Now, there is actually a whole lot of conflict specifically in Indian jurisdiction when it comes to difference in puffery, hyperbole, and exaggeration. In India, there is Advertising Standards Council of India, which is a self-regulatory body. It's called ASCI, and ASCI has come out with a code of conduct. Now, although it's a voluntary body, there are many government organizations as well as statutes who have placed reliance on ASCI conduct. So therefore, that code of conduct, Lily, were you saying something? Okay. So as I was saying, ASCI, right. As I was saying, ASCI is the body which has come out with a code of conduct for self-regulation. And that code of conduct has been adopted by various government authorities as well as various statutes. So that broadly gives us an idea of what an advertisement should comprise of and what it should avoid. Now, although ASCI is only a body which analyzes advertisements, and if your ad is misleading, it can issue a recommendation only. It can recommend that you should make these changes to your advertisement, or you should not air these advertisements. ASCI generally takes a very strict interpretation of what would amount to a misleading claim, right? So if we go by ASCI's interpretation to a certain extent, creativity could be limited. However, when courts in India take that interpretation, they say that the consumer cannot be hypersensitive. If a material or a claim by an advertiser is very obviously exaggerated, then the consumer should not take a claim that, I can still be misled. So therefore, the courts give a broad interpretation to what would amount to an exaggerated claim. However, the points that I just elaborated before, which is that you should have substantiation to whatever claims you're making, and the exaggeration should be obvious and not only understandable to a person who's skilled or who has background knowledge of the product. Those are very key factors in determining what would be exaggeration or hyperbole. To simplify it actually, the ultimate test would be what the consumer would perceive it to be. Another very important factor is, of course, public sentiment and consumer sentiment. Now, of course, there are certain broad definitions or broad factors which are agreed upon internationally. So, for example, it should not be indecent. It should not be discriminatory. However, the nexus of all of these also change with changing times. So something that, might not be very offensive at one point in time may later become hurtful to the public sentiment. Just to give a very small example, fairness creams is a very widely known concept in India. Of course, they've been in place for many years and they have a huge market. However, since colorism as an issue has caught on to not just because of social media, but also because of the consciousness of the coming generation and the coming times, it has become a big issue. And therefore, colorism is something that the brands have taken care of. And therefore, the brand advertisement, the brand slogans going forward are likely to change, keeping in mind the consumer sentiment. There was very recently a case where one of the dough makers had come up with an advertisement saying, "Are you permitting your maids to knead the dough with hands?" So there was a mass uproar against that advertisement, and they of course took it down and they issued an apology to the public, because of course they understood that even though their intention was not one to hurt the public sentiments, but unfortunately, since the effect was that is something that the advertisers and the brand owners have to be very conscious of. Now, another very important thing, and in fact a recent development, is that until recently, it was only ASCI, which is the Advertising Standard Council of India, which I just told about, was the only body which was sort of adjudicating whether an advertisement is misleading or not. And the only thing that it could do was issue a recommendation to say whether that ad should be taken down or whether it should be edited or moderated. However, recently there's been amendments in the Consumer Protection Act in India. And for the first time, there has been constitution of a grievance committee, which not only has the authority to determine whether an ad is misleading or not, but it also has the authority to penalize the advertisers, whether by way of fines or by directing takedown or any further action. So therefore, given the present specific amendment in the law, it would be even more incumbent on the advertisers and the brand owners to be very conscious of their content and advertisement, because in recent times this is a major development, because of which there could be substantial and concrete consequences of issuing false advertisement.
It's very in-depth knowledge in relation to what constitutes false advertising and how that really impacts global advertisers, plus the issues that they need to be considering. So thank you very much for that oversight, Surabhi. So I'm going
Thank
you, Lily.
Most
I would
welcome.
just like to add something to what Surabhi actually brought in here.
Sure.
So as she mentioned about the various aspects of how the Indian laws are catering to advertising, I believe what she said, and that makes a lot of significance here, is also how globally and how it is impacting, because what's more important is morally what is the content that is being created, and that moral responsibility and the law therein kind of lies and is very different in almost every part of the world, and yet quite similar. So I believe that's one aspect that she brought out, which was like quite, I kind of really liked it. So I thought that I would just add on to that.
Yeah, no, that's a really good point. And actually it's a great segue into a discussion that I'd like to enter now with Shun. So that's really good re-emphasis on that point. So Shun, you've worked in Shanghai, Hong Kong, and London, and advised on IP, unfair competition, including passing off and market abuse, information security, privacy and regulatory matters, focusing particularly on TMT, high-tech manufacturing and life science sectors. So advertisers, as you know, have the arduous task of trying to inform and influence to attract and retain a captive audience through the advertisements which they develop and produce. From an international perspective, what are some of the language issues, cultural matters, and regulatory restrictions, both on content and ownership-wise, which global advertisers and those wishing to protect their company through the registration of trademarks have to bear in mind?
Yeah, thank you. Yeah, for a multinational business, especially a brand or a product, when you enter into various jurisdictions, various markets, you always need to bear in mind the language, the cultural and regulatory aspect. Now, the first issue is about language. Supposedly, a foreign company, a Western company using an English Arabic brand, and went into China, although there are a lot of people in China can speak English, but naturally, Chinese people would prefer speaking Chinese. So it will be very advisable for the multinational company to create a Chinese version brand for the product or for the services. Now, let me give you an example. You know the great, the pharmaceutical company Pfizer. It has a kind of innovative drug, Viagra, to treat erection dysfunction. Okay, now this product is very successful, but in terms of technology and business, but not as the brand in China. Now, when Pfizer introduced the drug into China, on the advertisement, on the media reports, always use the English name Viagra, but the Chinese people create a very creative name for Viagra, Wei Ge, which sounds like Viagra, but the meaning is great man. So it's a very brilliant invention. Unfortunately, this name was created by the Chinese people, the public, the media. I don't know whom, but the media. Basically, everyone knows Wei Ge, the great man. Long before, Pfizer realized that the great man word referred to their product. And finally, a third party registered the name great man on its own product. Because Pfizer has never used the name and never registered name in China, so on no legal ground, it can get the name back. So this is kind of bad news for Pfizer. So
great example.
Always remember to keep in mind to create Chinese version brand. Now the second issue is about culture. Now, when we develop a brand, we always want to have the brand have a positive meaning, right, to refer to the product. But sometimes when we translate the name directly into a foreign language, the meaning will be changed. Now, in China, there is a kind of toothpaste with the brand, we literally translate into black man, or black people. No. No, yes. In foreign countries, in Western country, probably the name is discriminatory. It's not a good name. But in China, it actually means a kind of black image of people showing the white teeth. So it have a very positive meaning.
I see. Ah.
So yeah. So no. Fortunately, that company realized the possible negative meaning in the brand in Western language and change another version of the name to avoid any misunderstanding. So, luckily enough, now there's a cultural issue. And the third issue is about the regulatory issues. Now, different countries have different advertisement laws and have different restrictions on the words and sentences and descriptions need to use, which can be used on advertisement. Now, in China, superlatives are not allowed to be included in advertisement. So you cannot claim my product is best or it's super. We can't do that. It will be considered misleading because no one can prove that somebody's product is definitely the best. Okay. Now, I understand that in some Western countries, which some trademarks itself are superlatives. So, for example, in America, we have the brand Best. Now, Best Buy or Best Hotel, the Best is the brand. In the UK, they're Finest. Now, it's a Tesco's brand, Finest. Now, this brand just cannot just copy it into China. Otherwise, when you use the brand on advertisement, naturally, it will be considered a violation of the advertisement law. And also, now for a lot of multinational companies, they wish to have the trademark and other IP rights to be held in the hand of a parent company overseas. Now, it works for most of the circumstances, but not always works. In some occasions, for example, in the telecoms areas, now if you are running e-commerce platform or other operational for-profit internet platforms, you need to register the site with the government. And for cybersecurity reasons, the government also requires that the same company registered the website will be the same company to own the domain name and own the trademark corresponding to a domain name. So that 3-person must be identical. So whenever there is anything wrong happens on the website, the government can go to the person and say, hey, you need to correct it. Now, this is methodology behind it. So in that situation, the domain name and the corresponding trademark must be transferred into the China subsidiary of the multinational companies, and so that the identity of the registrant, the trademark owner, and domain name owner be the same person. Now, this is an example to consider regulatory issues. Yeah, that's all I want to speak. And last, I want to make a mini advertisement for myself. That is, I'm running a series webinar for my firm on IP one-stop guidance on IP strategy in China. So if you're interested in this topic, please feel free to register. I have post the link for registration on the chat box. Thank you.
That's wonderful. Thank you very much, Shun. They're really insightful. I think very insightful issues there you mentioned in relation to culture and language and regulatory restrictions, and it really ties in well in relation to the point which Kritika also made in relation to cultural issues. So thank you very much for those very insightful comments. So we're getting close to time, but last but not least, I'm going to turn over to Varun. Now, Varun, you have extensive experience in drafting, filing and prosecuting patents, trademarks, designs and copyright applications for various MNCs. In your experience, could you share with the audience some of the legal remedies available to brand owners and global advertisers If in fact they are faced with a trademark issue in the global advertising context, what tips and tricks can you share to enable brand owners to inform and influence in the context of trademarks and global advertising? Oh, Varun, I think you might be on mute. We can't hear you.
Am I audible now?
Perfect.
Yeah, great. Yeah, thank you for introducing me. So, in fact, I have been litigating in Delhi High Court for quite some time now in trademark cases and a lot of patent infringement cases, and from both sides, in fact, but mostly on the right holder side. So there is a positive news right now. So for even for global advertisers, that the Indian courts are giving a very positive uh, kind of a reaction to the right holders, and there have been so many cases right now regarding these issues, and one of the factors that have the courts have faced is the comparative advertisement that has become a lot of hot cake right now over here. So because India gives a lot of value to freedom of speech, but apart from that, it should not trespass into the rights of other people, or it should not be unfair use. And in fact, Trademarks Act section 29 it says that in any advertisement you cannot have any unfair use of another person's trademark, or it should not dilute its distinctive character, or it should not be misused. So in that ways, courts have what the courts are doing for advertisement is creating a balance between what is freedom of speech and what is the extent that can be allowed without trespassing into another person's trademark rights. So unlike the Chinese part, in India, we advertisements can say that we are the best. So that is allowable, and even they can say that we are best from our competitors. But yes, we cannot name like that. We cannot disparage the competitor or a particular brand or a particular competitor, name it and disparage. Although we can do comparative studies in the advertisements, we can name the competitors and we can show that because of certain facts, they can present the facts to the consumers. That so far it's allowed by the courts, and even the Advertisement Standards Council of India that Surabhi mentioned earlier. So even they have said that you can mention competitor's name, but you can compare only the facts and not just whimsical or some created or what you suspect to be, but it should be substantiable. For example, if you say that there is certain component in a competitor's product which is not good for health or good for skin, and that is at a very high rate, let's say it contains lead, then it should be substantiated by lab reports. It should not be something which is whimsical, that cannot be substantiated. So these are the actual boundaries that are demarcated, which determine the tussle between the freedom of speech and how much is allowed to compare another person's trademark. So there has been one case, Reckitt Coleman case, 1996. It's an old one in which the Delhi High Court allowed that you can say that your brand is the best, and even you can say that your brand is best from all your competitors, but it should not have anything that defames the other person's brand. Your advertisement should not reveal that. So apart from that, there is another recent case. There was parachute coconut oil case, and in fact there is one interesting one is Dettol case. I mean, Dettol is a very popular brand, so it had compared another soap bar and said that Dettol is much as a liquid soap, or it's much superior than a soap bar. There was a very famous soap bar. There is one in India, Lifebuoy. It's called Lifebuoy. The comparison was that although they were not using Lifebuoy, the trademark name, but the soap bar appeared more like that. So in any case, the court was not couldn't decide on that because the matter was settled before, and the advertisement was removed from broadcasting. But it brought about an important question that it's not necessary to disparage by really naming the trademark, but if there is any indication that it's the other competitor product indication of particular product, then also courts have taken into account that there has been a disparagement, although the name of the other person's trademark is not mentioned, and it's only indicated by shape or the product description, trade dress, or like that. So, and positive the thing is that the courts have granted a lot of injunctions where they have found that the trademarks are, the name or the trademarks of the competitors are being disparaged. And even ex parte injunctions have been granted by Delhi Court, mostly by Delhi High Court, and which is actually a positive news. So it's more balancing on the rights of the trademark than on the freedom of expression right now. So that's what I have to add over here. Yeah.
Yeah, no, very interesting insight. So I know that we're running close to time. I'm not sure if anyone else that they'd like to share with the audience in the last 2 minutes or so that we have, or whether or not we open up to Q&A. Hashita, we'll be led by you in relation to how we manage this last few minutes.
Just a small...
Does anyone...
Am I audible?
Yes, you are.
Okay, great. Just a small advertisement, like Zan said. So our firm, Sagar, Chandra and Associates, we do a weekly snippet series called Adlaw on our LinkedIn page, which basically covers various facets of advertisement law, not only from the brand owner's perspective, but also from the consumer's perspective, international jurisprudence, Indian laws, snippets and examples of interesting cases that have happened in advertising law all over the world. So I'm just going to share the link here, and whoever would like can follow that as well.
Absolutely. Thank you very much. I don't know if we have any questions. Sorry, Kritika, go ahead.
So just a quick one. I just would like to bring the discussion that we had. What I realized, one thing is that there's a very thin line technically between being competitive in the market and literally crossing the line and being probably defaming the other competitors. So I believe what's happening nowadays is there is a lot of competition when it comes to the advertising, because a lot of business is kind of dependent on the marketing and the advertising policies of every company. And what is important to note here is that the focus must always remain on ensuring that everything that is being catered for is within the four boundaries of the laws of the particular land. Because one thing that we all understand is, though we all understand how the trademark works, but at the same time there are other factors that need to be taken into consideration, other laws that would be required, and that can vary from different place to different place. But I guess that's one of the key aspects, that while we are working towards influencing and expanding and advertising, there has to be that awareness of where and how the advertising should actually be proceeding. So I just wanted to bring that discussion to a closure by just getting that.
Yeah, I think I agree.
That's really good point.
In fact, in India, it's more like self-regulatory, the Advertisement Standard Council of India. So if it could be more, made responsible to the courts or to the government, then I guess it would be fair direction to go to.
Yeah, in China, advertisement law is more complicated.
Go ahead, John.
Yes.
Yeah, it's not complicated. Not only regulated by advertisement law, but also unfair competition law. And in terms of pharmaceutical products, it will also be regulated by the drugs regulations and also a lot of rules on personal data protections. Product liability laws will also have a role in playing advertisement. So a lot of laws, regulations will be involved.
That's a really good point. So I guess I'll bring this one to a close, but if anyone has anything to take away, I think the key message is that there's a lot to think about when you're thinking about your trademark strategy in terms of your global advertising strategy as well. Obviously, there's a desire to inform and influence, but it's really important that when you're putting together your company strategy for advertising, that you really have a multifaceted and holistic approach towards that, having regard to the various jurisdictions you might be looking to play in, as well as the cultural and language issues as well. So certainly some things to keep in mind when you're actually looking at brand protection in your relevant jurisdiction through global advertising. So thank you very much to the panel, really insightful discussion, really nice cross-cultural sharing as well. And obviously to the audience, you're more than welcome to ask us any questions that you might have.
Thank you everyone for joining for this wonderful session. I think it's a very interesting topic, and I think Aradhana has also highlighted some of the points and make the statement that the widely reported dev toll, which I think Varun Sharma was also highlighting, the widely reported dev toll versus detol was really intriguing and maybe a major trademark infringement event of the pandemic in India. And apart from that, she's also highlighted Parle G versus Prem G. So
yes. There are multiple such scenarios actually, Mithali, if we look into it, there have been ample cases where, especially in India, like I said, there's a very thin line between being competing and, blatantly just going and, getting after another brand. So I believe that, yes, I completely agree with what Aradhana has also said actually. Yeah.
Audience, any questions for our key panelists? So you have 1 more minute either to join on the video and ask face-to-face question, or you can write on the chat box on your right. So any questions in 1 more minute to go, and then we can close the session. In the meanwhile, let's have a quick snapshot of all the beautiful faces, and let's take all the memories along with the conference gorilla. Thank you so much.
Thank you.
Thank you everyone for joining for this wonderful session, and I think all the audience would like to connect with you and will connect with you over the networking area. Okay, this was very interesting and interactive session. Okay, one of the person has given the comment on the chat box.
Thank you for the feedback. And thank you very much, Hachita, for inviting us as well to join the session. Really, really nice opportunity to do some sharing with you.
And now we are coming to the most interesting part of
Thank you so much, Lily.
Thank you, Surabhi.
Sorry,
So,
thank you. You were a wonderful moderator. Thank you.
thank you so much.
Thank you.